know who has invented this? Widely used in computers, the Intel chip. It was invented by an Indian who is called as father of Pentium chip, Shri. Vinod Dham has identified and has done this invention of Intel Pentium chip. So as I said that if you have property, how it will become an asset? The property, it will not become an asset. So there are two forms of properties, intangible assets and tangible assets. So whatever plots, flats or the physical infrastructure we have, we call it as a property. As we use some registrations, like for registering a plot or a flat, we register it with the boundaries. And why do we seek this registration? That we want to make our property secure. How will we make our property secure? By registering it with the government authorities, so that I will decide what to do with this asset. Say for example, I have an asset like a flat or a home. I will, once I will register it with the government, I will be responsible to make money out of it. I may give it to a rent, to on rent, or I may sell it, or I can keep it empty. In same way, we can convert intangible assets into economy. So as when we have registered property, we get rights to protect it. So what is our today's agenda? That how to identify intellectual property, what are the ways we can register for our intellectual property, and what are the rights that we have. And above all, which are laws and legislations are available in India for protecting different types of intellectual property. Okay, so this slide shows you that, say for example, Shri Shivaji Science and Arts College, Chikhli. What kind of asset you have? You have tangible assets, you have intangible assets. The tangible assets like the buildings, the infrastructure, the vehicles, the lab equipment, machineries, the furniture owned, the computers and other infrastructure owned by your institution is your tangible assets. Now, what are intangible assets? Whatever are created by the human mind, like logo for publicity of the institution, the brand value, or if you want, you may have different branches of the same institution, so franchises, or whatever work you are doing, so whatever technology you are studying, develop software, this will become your intangible asset. And above all the forms of intellectual property will be the intangible asset for an academic institution. If you look at this slide is an example. All of we know what is this. Okay, but we will today's workshop will help you how to identify, like IC. What is, if I invent a new IC? How to protect it? The trademarks, the copyrights. So these are different forms of intellectual property. Now, if I develop a technology or if I develop a device, so there are different intellectual properties available within a single product. Say for example, a mobile or a laptop. There are different IPs used in a device or in a laptop. Say for example, the external appearance of this laptop, it is protected under design, the body of laptop. The display device or the functionality of keyboard, it is covered under patent. You can see the logo, it is the Apple sign. It is nothing but the trademark used. So how to use a particular, what we can say, this device or a particular product. So user manual is ready with that particular device. So that is nothing but it can be protected under copyright. And the layout of ICs, it can be protected under SI design, semiconductor integrated circuit layout design. Now, convert or how to create an intellectual property. So this slide shows you that how an idea can be converted into a property. So see, uh, if if I say that intellectual property is nothing but the property created out of human mind. So wherever we go and we find a particular problem, our brain has multiple ideas to solve that problem. Then find out for the resources required to solve the problem, and then we put some efforts, we put some labor. So whatever outcome is there, it is nothing but your intellectual property. So as I said, that intellectual property is nothing but creation of the mind. So all the inventions like patents, literary and artistic works, the symbols, logos, names and images used in commerce. These are nothing but the intellectual property. So whenever we say a property, anything that we own, when we call it as a property, whenever it has some commercial value. So intellectual property is something produced by human intellect which has certain commercial value. So broadly, the intellectual property is divided into two categories: industrial property and copyright. So first of all, we'll see what are the intellectual property rights. Whenever a person owns an intellectual property and registers it with the government of India, then there are certain rights conferred to protect that particular intellectual property. So, the intellectual property rights allow the creators or owners of that invention, of patents or trademarks or copyrighted works to benefit from their own work or whatever efforts they have invested in the creation of that intellectual property. As I said, that intellectual property is governed by appropriate national legislation. National legislation means if I own a particular intellectual property in India, it will be governed by Indian intellectual property right laws. So basically, before going ahead, one must understand the difference between an invention and a innovation. So in the very first slide, we saw that Aryabhatta invented zero, P.V. Raman invented Raman effect or missile mission. There are certain inventions included in it. So whenever a particular brand new product or device comes into existence, invention refers to that. Invention refers to the creation of a brand new product or device. Whereas innovation is nothing but making changes to the existing product or the process by introducing the new ways or ideas. Okay. So, can anyone type in chat box whether I am audible? Yes. Is my voice clear?
Madam.
Okay.
Your voice is clear.
Thank you. Now, the industrial property and copyright. These are the two main parts of intellectual property. So, patents, trademarks, industrial designs, and geographical indications come under industrial property. And copyright is a different category. So, the copyright covers novels, poems, plays, dramas, film, music, or any artistic work like drawings, paintings, photographs, or architectural design. These are all part of copyright. So any one product, if you consider contains multiple IPRs involved in it. Like for what particular thing, which intellectual property is available, protection is available. So for the functionality of any device, how it works is protected under patent. The commercial branding is protected under trademark. So trademark gives you insight into to whom that product belongs. The external appearance or how it looks is protected under design. And for in case of this mobile phone, the software code or the GUI is nothing but the it is protected under copyright. These are few trademark examples that you may be familiar with. Now here we'll see the difference between IP and IPR. So intellectual property is something produced using human intellect which has certain commercial value. Uh, when I say intellectual property, it is an intangible form, but it can be, it is an intangible form, but it usually is contained on a tangible medium or a fixed medium paper or a CD or a computer chip. So these are all forms of intellectual property which is intangible in nature but can be converted into a tangible form. So an idea or an invention or innovation is an intellectual property. But when it is registered, then it becomes a intellectual property right of the owner. Customer database is an intellectual property, but when I want to keep it confidential, it becomes intellectual property right. If I don't want to disclose the method of production, it is what? An idea. It is an intellectual property. But when I take some steps to keep it secret, so trade secret is an intellectual property right. Okay, so what happens when I register for an intellectual property? So intellectual property rights are nothing but any property rights that it gives you the right or allows the creators or owners of the intellectual property, that is patents, trademarks, copyrighted works, to benefit from their own work. These are different forms of intellectual property. We will see in detail one by one. For a particular form of intellectual property, we have in India different acts, laws and legislations for protecting the intellectual property. So the Patents Act 1970 protects the patents rights of a patent owner. The Copyrights Act 1957 and the amendments hereafter uh, is used to protect the copyright. The Designs Act 2000 protects the industrial design. The Trademark Act 1999 protects the trademarks. The GI, that is Geographical Indication, Registration and Protection Act 1999, is used to protect the geographical indications. These are the respective laws. So only for trade secret, steps to be taken to keep it secret. And traditional knowledge, like as the principal madam has rightly mentioned, that haldi is our traditional knowledge. But we converted into intellectual property when some other country tried to own the right over it. So India has a lot of traditional knowledge, but it is our intellectual property. But it is not our right. Right? Anyone can make use of the traditional knowledge. So traditional knowledge is an intellectual property, but it is not anyone's right. Now coming to patents. So a patent is an exclusive right granted for an invention. Invention may be a product or a process that provides a new way of doing something, or it may offer a new technical solution to a problem. So this is what we can protect for a patent. A product or a process that provides a new way of doing something or offers a new technical solution to a problem. So what one should do to get a patent? The technical information, the know-how of the invention must be disclosed to the public in a patent application. So how long one can enjoy the rights conferred with a patent? So we call it as a term of a patent. So when a patent is granted to the inventor, uh, he can enjoy the patent rights up to 20 years from the date of file. Appropriate fees is to be paid for maintaining the patent. Now, uh, who can be the patent owner? So, any true and first inventor, assignee, or legal representative of the inventor can file for the patent. When so all the academicians must know that to if you have certain idea and you have awareness about the intellectual property rights, so what you should do that instead of publishing it in public, first you should protect it and share it in public. So when to protect your intellectual property, sooner the better. First to file or first to file is the easiest way to protect your intellectual property. Sooner the better. Okay. So you can have provisional as well as complete specification. You have two ways. And where to file? Now the procedure for filing a patent or intellectual property is completely made online by the Intellectual Property India office. Some of the famous Indian inventions, patents, all of you may know, must know this Jaipur foot, hepatitis vaccine and nano card. So India can produce as simple
Explain,
as
madam. You are
yes, yes.
asking for.
Now I'm getting some noise. Hello, hello, hello. Yes, ma'am.
Please continue, ma'am.
Okay. Am I audible enough?
Yes, ma'am.
Is the flow good, ma'am?
Very good, madam.
Okay. So these are few simple invention like the first picture you can see, or it may be as complex as drone or some smart card. Now, second form of intellectual property is copyright. So, copyright, whatever literary work you create, you may have your project reports, your research papers, findings of some case study. So you can write it down, but it should be original work. Okay. So the copyright is governed. Copyright is given granted to the author for an original work. So what can be that original work? It can be as simple as poems, articles, essays, literary or dramatic work, musical work, or even dance forms, artistic works, movies. All these come under copyright. So it gives the creator the exclusive right a time. For exclusive right means for that particular amount of time, the owner has the control to use that work, use the copyrighted work. How you can, whether you want to publish it or how you want to reproduce it or you want to perform it on some platform or display it some at some places. Uh, Copyright is what it gives you benefit for long term. Like if someone creates a unique literary article at the age, certain age. So copyright term for that particular article is the lifetime of the author plus 60 years. So for that much amount of time, you can enjoy the benefit out of your copyright work. But do I need to register for the copyright? Basically, whenever you write something, immediately copyright comes into existence. when it is created. No formality is required to prove that it is your work. But why do we need to register for copyright? Because in case of some infringement or unlawful activity, you should have the registered copyright. So in the digital era, you should have maximum copyright because we produce many a work. So original creators are always respected in the uh, copyright regime. So for the rights, so there are multiple rights for a copyright. It allows the owner to choose the ways we want to use the copyright or how we want to make the copyright material available to the public, and one can prevent unauthorized use or copying of the work. See, uh, I want to make a thing clear that copyright is not for an idea. Here you can see copyright protection is not available for an idea. Copyright is available for expression of idea. So that, see, all of us know that Bhagavad Gita, who told, means Lord Krishna told to Arjun, right? But they are the owners. But that idea is expressed in different languages and in different forms. So each of the author or publisher has the right to. Okay. So always copyright is given for an expression of idea. The same can be applicable to the movie industry. A same idea like someone. So if there are four producers, four are giving all the same, but they have their own copyright because the expression of idea may be different. Okay. Now coming to industrial design. So here at this point, I want to give you a live example that our research guide, Dr. Mukti Jadhav Madam, uh, the group of her lab worked on different problems, and the research outcome, whatever research outcome she had, she suggested us for protecting it through some form of intellectual property. So, Madam has registered the design of one of the invention for micro cantilever based biosensor. So we have two forms of intellectual property protected for it. One is we registered a design for that, that is the external appearance, and one is we filed for a patent also. Recently it has been published for that. So one product can have multiple ideas. So Mukti Madam has given us the example that how can we uh, protect one invention by multiple IPRs including it. So Madam has copyright also for the research papers. She has registered design, and she has guided us to register for a patent also. So one research outcome of a student has added the knowledge, added to the existing knowledge. So here you can have that awareness that whatever I have created is original and I want to share it with others, as well as I want to establish that this is the original work. So the best way is to identify your own intellectual property and register it with the intellectual property office. Understood? I hope all the students and researchers are getting the insight into that how your academic interest can add to the intellectual property of your own. Okay. So the example is copyright for research paper, project work, case studies. You can have copyright for that. Then, if you have some created something which has some external appearance, artistic look, so that has certain feature of shape, configuration, pattern, or ornament. So you can go for registering the design. So for the design, it must be and the design must applied by an industrial process. So these are the some area have industrial in the design. See what is required, what technical knowledge is required to have a registered design. What idea you have for making a product innovative by changing the shape, configuration, surface configuration or surface pattern, jewelries, the design of a product, external appearance of a product can be protected under register. How long I can one can enjoy the protection for a design? So duration of protection of registered design is for 10 years and which is extendable for another 5 years. So now so that we can have different shapes and features of bottles or some containers. It is up to your creativity. Now, school children may have different sharpeners, erasers. So, when the awareness about registered design spread into the market, nowadays the research scholars or the professors may be agree with me that they had to buy different sharpeners, erasers, and pens. Earlier, there was a very little awareness about the design. Okay, so this is what how your creativity can add up to your intellectual property. So the design of toys, pens, biscuits, anything can be protected under industrial design. Okay, so you must you what you need just to make yourself aware that what can be protected under industrial design. Trademarks. So trademarks is completely a commercial entity. Whatever product or service you have, your college has a logo. So what you can use this mark, registered marks for the for making your intellectual property popular in the marketplace. So there are different types of trademarks. Some are word marks, numerals, device mark, color mark, or characters. The if someone registers for a trademark, so it is granted for a term of 10 years, which can be renewed in perpetuity for every 10 years. So unless and until you are filing after continuing your trademark application after every 10 years, it can be uh, used as long as it is renewed. Now, this slide shows you the difference between use of TM and use of R. So, all of us come in contact with some advertisement containing TM or R. So, what is the meaning of TM and what is the meaning of R? So, when your trademark is in the registration process or your application is pending, uh, TM can be used, but R can be used only if the trademark is registered. So, whenever you see a particular sign R, you can identify that it is a registered trademark. Now, coming to a very popular form of intellectual property, geographical indication. Basically, we are consumers of this property, but we are not aware that I should respect this intellectual property. Okay, geographical indication. The tagline for India's geographical indication is "Atulya Bharat ki Amulya Nidhi," invaluable treasures of incredible India. See, uh, can you tell me any guesses about this slide? You can type in the chat box or you can unmute and answer. Yes. Unmute and ask. Color and shape different. Correct. But anyone knows which place is famous for that particular fruit or product? You can type eating or using. Okay. See, the first leftmost top corner is Hapus or Alfonso mango, and the rightmost corner, both are mangoes. We purchase, but we have forgotten the link between the geography where from where the product has come into the market. So Alfonso, all of us know that it is from Konkan, but this is from Marathwada, Kesher mango. So the users or the authentic users can identify the difference between the two. Pomegranate is from Solapur, banana from Jalgaon, Wangi from Jalgaon, Kolhapuri chappal. So these are what geographical indication means. They have some particular characteristic related to the origin or based on the climatic condition and geographical location of that particular area. Because of the climatic condition and because of the geographical origin, that particular product has a particular color or taste. Okay, so we have various examples of geographical indications in India, such as Darjeeling tea, Kanchipuram silk saree, Alfonso mango, Nagpur orange. So Nagpur orange is the famous geographical indication, Kolhapuri chappal. So across India, there are various geographical indications registered. So what is the peculiarity, which can be a uh, geographical indication? So GI is an indication used to identify agricultural, natural or manufactured goods that is originating from a definite territory in India. It should have a special quality or characteristics that is based on the climatic condition or production characteristics that are unique to the geographical location. Examples of geographical indications that we have already discussed. You can also find out the original products from your uh, region. Now, important part of intellectual property, that is layout designs of integrated circuits. See, engineering students must be aware of these this type of intellectual property, that is layout designs of integrated circuits. When a company or a particular researcher uh, launches a new product with some feature or it has some layout of the circuit for it, then it can be registered with the layout design of integrated circuits. So the Semiconductor Integrated Circuit Layout Design Act 2000 is used to govern the registry of this form of intellectual property. Again, one important form of intellectual property is plant variety, which is awareness of this Plant Varieties Act will be helpful for farmers and the plant breeders. So the awareness about the Plant Varieties Act is has certain objectives to provide for the establishment of an effective system for protection of plant varieties, provide the rights of farmers and plant breeders, to encourage the development of new varieties of plants, means research in agriculture you can have one of the objectives, to stimulate investment for research and development and to facilitate growth of the seed industry and to ensure availability of high quality seeds and planting material of improved varieties to the farmers. Again, as in the first few slides, we have discussed all the forms. So one is trade secret and other is traditional knowledge. So as we know, all of these forms of intellectual property, but you can have a trade secret also. You will not disclose it to anyone, or you can, if you are disclosing it to others, it will become a part of traditional knowledge. So how the intellectual property laws in India work? It is a affirmative right, means it allows you to stop others. But when you will stop others from using it, when you will identify that someone is using your work without your consent. Allows the owner to file a lawsuit against the infringer, but it is not able to stop the infringer. Okay, so now we will have the quiz. Yes, identify some famous trademarks from this slide. Type in the chat box. Yes, participants, students, look at the slide. It is not a difficult quiz. Yes, students, type the maximum trademarks that you identify from this. Can someone spot or you unmute and answer? I will ask the organizing committee not to issue certificates for this, if you are not participating. Yes, R. Pepsi, correct. Coca-Cola, A. Lux, good Sakshi. Amul, yes. row and column and try to correct it all. Tata. Good. Yes. Bata. See the answer slide. So this quiz gives you that it you have common, all the brands is common. But if I take some efforts to make it different, I can spot it. So this is what intellectual property right regime does. How you stand out from others. What efforts you need to take. So if I give you awareness that these are the brands, so you can easily locate. Yes. From this slide, find out the intellectual property. So in the chat box, write the number and in front of the number, write which property that image has. Yes. What is one? Yes, water, but what is the form? Whether it is a patent or copyright. Yes, you identified the Apple logo. Correct. But what form of property it is? Correct. The third is design, the external appearance. Very good. Okay. So the first is the simplest example of a patent as well as a design. External appearance can be protected with the help of design and functionality, how it works, is protected under patent. Second is also a sculpture. Sculpture can be protected under I will leave it unanswered. Sculpture. Third, someone has rightly answered that it is the external appearance, it is design. Fourth is a logo. So it is trademark. And fifth, the shape and features of the Coca-Cola bottle is protected under design. number? The sixth and seventh. Whatever is literary and artistic work, it is protected under copyright. Translation of Bhagavad Gita from one language to other, it can generate more copyright. Yes. The tenth image is of a patent machine or a product or know-how that how that particular thing works is protected under a patent. And if the complete bike is shown to you, so its color, shape, it is protected under design. Okay, so I repeat the answers. The image number 6 and 7 are the geographical indications registered GIs of Maharashtra, Puneri Pagdi and Paithan. See, Paithan. Bhagavad Gita is a copyright. The external appearance of the bike is the registered design, and the image is part of a patent disclosure, the design, the drawing. So, if it explains the functionality that how that bike will work, it is disclosed under a patent. So takeaways of this today's workshop is we understood throughout this workshop that what are different forms of intellectual property, and for new invention, how I can protect that intellectual property, or what is the original or creative artistic form protected with. So patent is conferred or granted for a new invention or innovation or a technological advancement over a product or a method. How it is done? It is done with an application and uh, patent examination. Copyright is granted for the authors original creative or artistic forms. Basically, copyright exists automatically. If any article is created, the copyright is automatic. But for conferring rights over the work, you should register it. Okay? Trademarks are given for distinctive identification of product or service. You have to register. The external appearance or ornamental design of the product is protected under registered design through a registration process. Integrated circuits can be granted for designs in semiconductor ICs or topographies by a registration process. A group of producers or a group of authentic persons can register the unique characteristics for a unique climatic condition based product or geographically location based products through a geographical indication. And trade secret are the ways or the measures to prevent your information to be in the public. Because of these know-hows and patents or intellectual properties shared, we could survive the COVID situations. Thank you. If you have any questions, basically the quiz was interesting, and I hope you have gained some of the insight on intellectual property rights.
Thank you, madam. Thank you for such an intellectual, valuable knowledge and simple live examples on IPR. Sure, our participants has cleared their concept. Thanks one again. Now the last part of workshop is vote of thanks. On behalf of the Department of Computer Science, I, Dr. Mukti Zadav, organizing secretary of this national workshop, would like to express my gratitude towards everyone who helped the successful organization of this workshop. I am thankful to our college principal, Professor M.T. Nikam Madam, for giving us permission to conduct this workshop. I am thankful to resource person, Dr. Pramodini Dange Madam, for sharing her expertise and the advancement in the area of intellectual property right. Thanks to organizing team, HOD, Dr. A.B. Kadamsa, Dr. Sonali Gaikwad Madam, Mr. Sachin Savan, Mr. Pradeep Sonone. I am thankful to my college colleagues. Thank you all for the active participation in workshop. Without you, this event could not have been possible. Thanks once again. Thank you, Punja Madam, once again.
थँक्यू सो मच मॅम. तुमचे आशीर्वाद आहेत म्हणून होत
मॅडम
आहे.
तुमची मेहनत आहे, बाकी काही नाही.
डायरेक्शन आहे ना गाईडचं, गुरुचं. ओके मॅम.
थँक्यू.
थँक्यू मॅम.
The workshop is over. Thanks all participants.